Welcome to Probate 101, your roadmap for selling an inherited home and completing the probate process with less stress. In this video, we are going to just talk for a couple of seconds about what is probate. Second, we are going to talk about some of the probate myths, and then we're going to spend most of our time on the roadmap for selling a home during the probate process. And part of the reason I'm doing the process and some of the tips for selling your home together and put them into a roadmap is because when you're going through probate, a lot of times when families run into trouble is when they don't follow the proper sequence. They do things out of order. It causes issues, causes delays, and ultimately causes more money with the title company, with other real estate agents, or with your attorney. So I've laid this out in into a roadmap for you to follow. So who am I? My name is Reine Kassulker. Reine sounds like green. And I'm a Minnesota real estate agent. I specialize in probate real estate. And more importantly, I have firsthand experience as a personal representative. I have been a personal representative twice, and I have been a special administrator once. And I help families who want less stress during the probate process. So my services go beyond just selling the home. I'm really here to help you, your attorney, and your family get through the probate process. Now, let's do a disclaimer before we jump in. First, I am not an attorney or an accountant. I am not providing legal or tax advice, and information in this video is for informational purposes only, based largely on my experience as a personal representative and as a real estate agent who has helped many families through the probate process. So let's start with a high-level overview. What is probate? And probate is a legal process that involves the execution of a will, or if there is no will, the administration of a deceased person's estate. And key tasks include securing assets, liquidating assets, settling debts, and distributing the remaining assets to the rightful heirs or beneficiaries. I think one of the most important things to call out on this slide is that probate is a legal process and it involves the execution of a will. So we'll talk about this in myths in just a second, but some people believe that if they have a will, they don't need to go through probate, when actually the opposite is true. If you have a will, you need to go through probate to execute the will and close the estate. And then if there is no will, you still need to go through probate, but you close the estate based on state law rather than the instructions of the person who passed away. So we'll talk more about that in just a minute. This definition that I provided came from Microsoft's AI assistant. And I asked Microsoft, the AI assistant, how it wanted to be cited. And it said, just mention that the definition was provided by Microsoft's AI assistant. So there you go. That's what I have done. Let's talk about a few probate myths before we jump into the roadmap. The first myth I mentioned already, people think that they don't need probate if they have a will, and it is actually the opposite. If you have a will, you need to go through probate in order to execute the will. And then when there is no will, you still need to go through probate in order to close the deceased affairs, accounts, and estate based on state law in the absence of a will. And one other thing I should mention in this video, I'm not making this video specific to any state. The process in each state is very similar. So if you get this high level understanding of probate and how to sell an inherited home, for the most part, it's similar in every state. The difference might be in the specific state statutes or the terminology that they use. So when I talk about a personal representative, that's a term we use in Minnesota for someone who's been court appointed. In some states, that person is referred to as an executor. In some states, that person is referred to as an executrix. And in some states, that person is referred to as an administrator or special administrator. So for purposes of this video, I am going to use the term personal representative because that's what we use in Minnesota. And again, I'm keeping this high level so that you can learn more about the process and know what to ask your attorney, or if you're working with a real estate professional, you'll have some good ideas of the process and what questions you should be asking. So myth number one, we don't need probate if we have a will. That is a myth. You do need probate if you have a will, and if the estate qualifies to go through probate based on state statute. All right. Number two, we don't need probate. We already have power of attorney. This is a big myth. And the reason is power of attorney ends when the person you were helping out dies. So if you had power of attorney for your parent and your parent passes away, then your power of attorney expires when they pass away. And that's one of the big challenges with probate. And causes a lot of stress. People think they have power of attorney. And there's this period we call the pre-probate period, which is between the time a person passes away and the time that the personal representative has been granted authority by the court. That time in between, that pre-probate period, you don't have power of attorney anymore. You've lost it. And so that could just cause problems for how you want to manage finances and manage the estate. We'll talk more about that when we get to the roadmap. Next one, we don't need probate. We're not selling the house. This is a huge myth. If you are transferring title of a deceased person in almost every single state, at least that I know of, you need to go through probate in order to have the authority to transfer that title. Even if there's a will that says you get the house, you still need to transfer the title into your name. Now, there are situations where people don't do this. They skip it. They choose not to transfer the title or not to go through probate and transfer the title. And it causes huge, huge, huge problems down the road. Huge problems. So it's better to, if you're transferring a title, even if you're keeping the house in the family, go through probate, get that title transferred properly, and it'll save you time, money, and stress down the road. I promise you. I'll use more examples as we go through the roadmap. And next, we do not need a probate real estate specialist. Selling a probate home is no different than selling any other home. This is mostly a myth, okay? There are some aspects of selling a probate property that are similar to selling other real estate. However, the pieces that are different enough that if you're working with someone who doesn't understand those pieces and you run into trouble, it's going to cost you time and money. I know what you're saying. I have an attorney to handle those legal issues. If the real estate agent you're working with doesn't understand the process and some of the legalities that you are facing, they're going to spend more time. Either they're going to make mistakes or they're going to spend more time talking to your attorney. And each time they talk to your attorney, it's going to cost you more money, right? So you can really save a lot of money and a lot of headaches by working with someone who knows the process. And we will talk more about that later. And if you're wondering, where do I find someone like that? You can reach out to me at any time. I have a network of competent probate professionals across the country that are available to help you in any state, any county. So it does make a difference, and we'll talk more about that as we go through the process. So let's talk about the roadmap. And what I've done is I've divided this into 4 phases based on the legal phases. So we have pre-probate, we have the appointment phase. This is where the court appoints a personal representative. We have the administration phase, where the personal representative is doing all the work that needs to be done to complete settle the estate and complete probate. And I should point this myth out. A lot of people believe that personal representative isn't going to have to do anything during this administration phase because you have a great lawyer. Unless your attorney is also providing those administrative services or fiduciary services, then all of that work falls on you, the personal representative. And sometimes I see families get bogged down because personal representative is waiting for the attorney to do something, and the attorney's like, hey, I filed the paperwork, you're good to go, get it done, right? So this is a scenario we're working with a um, real estate agent who understands the probate process, can kind of step in and fill the gap and help guide you through that process so that you can get the home sold and so that you can complete probate and get your payout. All right. And then the last phase is the closing phase. That is closing of the estate, not closing of the real estate. So I also then have sections for what we do with the real estate during these legal phases, or the phases of going through the probate process. So for example, in pre-probate, we would focus on securing the home. During the appointment phase, we're going to start cleaning out the home and getting it ready to sell. During the administration phase, we're going to sell the home. And then during closing of the estate, we're going to make sure that the title has been properly transferred. People wonder why probate takes so long. A lot of times it takes extra time when the steps are not followed. So if you start to do things out of sequence, and we will talk about that as we go through and I give you some tips. So let's start out with pre-probate. What are some things that you as a personal representative or family should be thinking about in the pre-probate phase? And again, pre-probate is that time where you have lost a loved one and you have not yet been court appointed as personal representative. So what do you do during that pre-probate phase to make the entire probate process less stressful? Well, first things first, deal with the personal matters, right? Take care of the funeral. Take some time for self-care. Take some time for grieving. There's a lot of work you have ahead of you, and there's time to get that work done. During the pre-probate phase, really focus on self-care, grieving, and the funeral. Number two, you can start to locate important papers that are probably in the house or coming in the mail. Some of those might include the will, Social Security. I encourage people to deal with Social Security right away. And the reason is that if Social Security is doing direct deposits into your loved one's account, and you don't notify them because you want the money to keep coming in, when you finally notify Social Security, they'll look at the date on the death certificate and they will go back and they will withdraw funds back to the date when the person passed away. So you think you have this money in the account, and all of a sudden you had to pay back Social Security, and they won't wait for you. They'll just do it. And so take care of that right away. Locate important papers on bank accounts, insurance policies, stocks, bonds, etc. And some of these items, like bank accounts, there could be a transfer on death, but in many cases there's not. There could be a beneficiary on the bank account. In many cases, there's not. Insurance policies, if they have a beneficiary listed, then they don't need to be part of the probate process. You would just file a claim as the beneficiary. And same thing with stocks and retirement accounts. If there is a beneficiary listed, then they're excluded from the probate process. And that's important because if you're not transferring real estate and you get rid of some of those big ticket items like the bank account or life insurance policy or stock account, that might lower the threshold enough that you don't have to go through a full-blown formal probate process in your state. All right, and each state is different. Each state has a different threshold. So, for example, in Minnesota, if the estate is worth less than $75,000 and there is no real estate, then you do not have to go through probate. I know some other states, I think Montana is like $100,000. I think California is somewhere around 160 or $170,000. Texas, I can't remember the amount. I think it was around 175 or 100,000. So each state is different. And if there is no real estate and the estate is below that dollar amount set by your state, then you don't have to go through the full probate process. You could just do a summary judgment in some states, or you could do affidavit of a small estate. Each state calls it something different, but that's important to note. So next, you need to continue to pay the decedent's bills during this pre-probate phase. I will give you an example here. Sometimes the bills are set up for auto pay, and you have money coming in from a retirement account or annuities, and you can use that money to continue to pay the bills. Other times you might have to pay the bills out of your own account. And if you do, just keep good records because you can deduct those from the estate expenses later on. But you got to keep making that mortgage payment. When you are going through probate, if you are not making the mortgage payment, or you stop making the mortgage payment, or maybe your loved one was sick and they stopped making the mortgage payment before they passed away, your house or the house in the estate is now going into the foreclosure process. Foreclosure does not stop just because a person passed away. The bank will just keep moving forward through that foreclosure process. And what will happen is you will end up dealing with foreclosure to try to save the house and dealing with probate simultaneously, which will increase your expenses working with the attorney. And you will not be able to negotiate with the bank until you've been appointed as the court-appointed personal representative. So try to keep making those mortgage payments so that the house does not go into foreclosure. This is a trap that I see for a lot of families. They don't realize this, and either they stop making the mortgage payments or they didn't realize the mortgage payments were being made. They think that it'll all get straightened out as part of probate, and then the foreclosure process kicks in, and now you have a different problem in addition to probate. So that is one way to really limit the stress while you're going through this process, is keep paying those bills. Next, I recommend families to forward the mail. This is important for a couple of reasons. Number one, it helps you find some of those important papers we were talking about. A lot of people who have passed away still have important papers coming through the mail. And in addition to that, you don't have mail piling up at the house. So make sure you forward the mail. And you could go out to the United States Postal Service website. Last time I did it, it was like $1. And you can do that very easily. Number 5, I have contact the banks, but I have it with question marks. And the reason I have it with question marks, this is a really common mistake that a lot of family members make. They go to the bank right away, and then they find out that there was no transfer on death. They find out that there was no beneficiary on the bank account. And they find out that the bank is going to freeze the account because the person passed away. And now that makes it really hard to pay those bills with auto pay, especially if there's money coming in. Now that account is frozen. It makes things very difficult. So I recommend that you not contact the bank during this pre-probate phase. So I'm putting a red line through that one. So Reine, you're saying, what do we do? I'll talk about that in just a minute. Let's jump down to securing the home. During pre-probate, you don't want to try to sell the home. You don't want to start talking to investors. You really just want to secure the home at this point. So first thing I recommend is change the locks. This is important for a million reasons. I'll start with some of the obvious reasons on cases that I've worked on. You would be absolutely amazed how many people have keys to your parents' home or whatever home is in the estate. So many people have keys. I worked on one case where the neighbors had keys, friends had keys, former colleagues from work had keys, even though they hadn't worked, this person hadn't worked for years. They still had colleagues out there with keys. The lady that did the Meals on Wheels had keys. The person who did the home healthcare had keys. The person who was coming in to help out with cleaning had keys. Also, the attorney had keys. Almost everybody had keys except for me. I did another probate case where there was a neighbor that had keys, and the personal representative and I didn't know it. And we had the house listed. And later, when we closed on the house, the other agent and I were talking about the neighbors, and she said, "Oh, was that the neighbor we met when we came and toured the house?" And I'm like, "I'm not sure. You know, was he out back in the alley?" She said, "No, he was in the living room." And I found out that this neighbor had keys, and every time a car would pull up to the house in the front, he would go into the back, let them in, and give people a tour of the house. I mean, he was even screening his potential neighbors, and I think maybe even scaring some of them away. So it's a really big problem. You also have problems with people who might go into the house and remove stuff or start donating stuff, or they think they were supposed to get something, or if you're organizing, they might start moving things around. And so it just makes it more stressful. Also, you want to prevent squatters from moving in. So change the locks. And squatters, I should mention, squatters can be someone from your family. It doesn't have to be a stranger who just moves into the house. All of those scenarios happen. So change the locks. Next, number 7, insure the home. And you're saying, Reine, I know the home is already insured. Wrong. The home is most likely not insured. Again, once a person passes away, and if the house is vacant, then a lot of times the homeowner's policy is no longer valid. And so even if you're making those mortgage payments and the escrow payment is going through to the insurance company, you want to check with the agent to make sure that that house really is insured, because I will tell you in most cases it is not, or at least in many cases that I've come across, it is not. And families don't find this out until it's too late. So call someone, call the agent, ask for a vacant policy, or ask if you need a vacant policy. If you do, it's going to be a lot more expensive than your traditional homeowner's policy. It is well worth it. Your attorney will probably recommend it if you have this conversation, and I recommend it as well. The house is typically the biggest asset in the estate, and it's sitting vacant. And as I already mentioned, maybe people have keys to it. People might come in and steal the pipes or the furnace or the mechanicals. You want to secure the home and insure the home. Number 8, arrange with someone for maintenance. You can have someone in the neighborhood come and shovel the sidewalks. In Minnesota, we have to do that all the time. Maybe have someone come over and mow the lawn, or hire a service to do it. Those expenses would be deductible from the estate expenses, but it helps you. It helps make sure that the house is maintained and that it looks lived in, and again helps prevent squatters from coming. So those are some tips for pre-probate. Let me know if you have any other tips or concerns about what to do during this pre-probate phase. One last tip I'm going to give you in this phase, and I don't have it on the slide deck, even though I said don't sell the house during this phase. And again, you can't sell the house during this phase anyway. Even if you have a will and you're named as executor, you will get to closing and find out that you can't sell the house and you have to go back and start over. It's a nightmare. And if you're working with with a real estate agent who doesn't understand this, they might be really eager to sign the listing agreement, get the house on the market. You find a buyer, you get to closing and find out that you can't close. This will cause you a lot of problems if you try to sell the house during this phase. What you can do during this phase is let family members know that you're planning on selling the house if you are, and also let them know that if there's anyone in the family who would like to live in the house or buy the house, now is the time for them to talk to a lender and get pre-approved, so that when you are ready, they can buy the house and you don't waste any unnecessary time. So don't try to sell the house during the pre-probate phase. Only focus on securing the house, and then let family know that if they're interested in buying it, now's the time for them to get pre-approved or pre-qualified. All right, let's go on to the appointment phase. In the appointment phase, you're going to file your probate case with the courts. You are going to submit the will to the court, and the court will appoint, most likely, you as the personal representative, or in some states it's called administrator or executor. So this is something that you should do as quickly as possible. There is no time limit. I don't have a time limit and say you should do this within a week or 2 weeks. You should do this as soon as possible. The reason why, we talked earlier about power of attorney ending when the person dies. When you get these letters from the court, letters of administration or letters testamentary, depending on what your state calls them, when you get the letters from the court, that is essentially the court giving you that power of attorney so that you can start to conduct business on behalf of the estate. That is what you need in order to negotiate the mortgage payment with the banks. That is what you need to go to the banks and start talking about closing accounts and transferring funds. Those papers are just absolutely critical. So I encourage families to file as soon as possible, because there's no telling how long you're going to have to wait before you get your hearing, or how long it's going to be until the court issues the papers. Sometimes they issue them immediately if it's an informal case. Other times it could take months before you get a hearing, and then couple more weeks to get them in the mail. So file as soon as you possibly can, because it could take a while before the court issues papers and appoints you as personal representative, and those are critical. Next, during this phase, we want to start cleaning out the home. And for step 12, what I recommend is that you contact a probate real estate agent before you start cleaning out the home. In fact, I recommend you do this right away, and not necessarily because you want to list the house with the agent, but because you want to come up with some strategies to help you complete the rest of the probate process with less stress. And that knowledgeable agent is going to help you decide if you should take a cash offer and get you the best cash buyers, if you should go with an iBuyer, or if you should put the house on the market. They're going to talk to you about all of those things. Notice here I said someone with probate experience. The reason why I don't recommend, even if you're going to hire a traditional agent, I don't recommend you start out by talking to the traditional agent, because the advice they are going to give you is clean up the house, make the repairs you need, and then we'll list it. That might be the worst strategy for you. That might cause the most liability for your estate. It might be unreasonable, right? You really want to talk to a real estate agent who understands the probate process and can assess your situation and give you the best options and let you know why they're the best options. Traditional agents should not be in the conversation at this point. That's my bias. A lot of people will bring in a traditional agent at this point and everything will go just fine. Others will bring in a traditional agent and they'll have all kinds of problems and they won't understand why. And then they start running up bills with the attorney because the traditional agent's talking to the attorney when they should be just taking care of business. It can get really expensive really fast. So start with someone who knows probate, assess the situation, and then decide what you want to do, even if you decide to go with a traditional agent. Number 13, determine approach. I already talked about that. Some of the approaches that are going to come up. Number one, cash buyer. As soon as you file with the court and they issue your letters, your name is on the public records, and cash buyers are going to start sending you postcards like crazy. You won't believe, and they're all going to say the same thing. Some of you have probably already seen them. My name is so and so. I buy houses. I can close in as little as 7 days, all cash, no clean out, no realtor fees. Sounds great. Okay. And in some cases, it is great. There are a lot of cases where it isn't. It all depends on your situation. And we'll talk more about that. But the cash buyer is going to offer you approximately 60 to 70% of the after repair value of the home. So if you go out on a website like Zillow or use one of mine, HomeBot is really good, which I provide for free. And let me know. I'll send you a link. If you look at the value on one of those tools like HomeBot, then just figure 60 to 70% of that amount is going to be what the cash buyers are going to offer you. And you can spend a lot of time. You could call 10 different cash buyers. They're all going to come in at that 60 to 70% fee. And then every once in a while, you'll find one that'll come in higher. And it turns out that they're a wholesaler with no intention of buying your house. They just want to get it under contract and try to sell the contract. That's a nightmare. I'll do a whole separate video on that. At this time, just know that your cash buyers are going to be about 60 to 70% of your after repair value. iBuyers come in a little bit higher. They're typically 70 to 80% higher of your cash buyer, but they're a lot more picky about what they buy. They have what's called a buy box. They want the house to be in a certain condition. And if the house is not in that condition, they won't buy the house. They will also make initial offers that are higher than what they're really going to pay. So they'll start out with an offer that might be closer to 90% of the after repair value. And then when they do their inspection, they'll start to lower it down. Even though they're not asking you to make the repairs, they're deducting for the repairs they have to make. And so they're still a little bit higher than a cash buyer, but only if your house qualifies. And you can spend a lot of time going through process with them to find out if your house qualifies. Next would be listing as is. This is in red because this is what I typically recommend in probate cases, not just because we net the highest amount, but also because it provides a lot of liability protection for you and for the estate. We use a lot of tools and waivers and language in the forms here that attorneys recommend and that attorneys love. And it'll just save you time. And I'll do another video. I will show you how you can net more in a probate case by listing as is. One of the other things I like to do for my sellers and families I work with is I like to bring in the offers from the legitimate cash buyers. I'd like to bring in at least 3 offers, maybe an iBuyer if I know that the house is going to meet the buy box. Then we take a look at those offers. Then we list as is to see if we can beat those. And almost every time we can beat those. Or maybe we put a time box around it. We say we're only going to put the house on the market for 2 weeks to try to beat these cash offers. And if we don't beat the cash offers within 2 weeks, then we're going to go with the cash buyer. So I use these things together to help families have more options and make sure that they're getting the most for their home. This is not something that every agent will do. Also, note that if you decide you want to do this yourself because you want to save on fees, you start calling the cash buyers. You have to go through a huge list to find out which ones are legitimate. You have to spend time having them come over to look at the house. And same thing, if you go with an iBuyer, you could invest weeks into the process. If you work with an agent who can lay out these options for you up front, for example, I just worked with a person the other day who was trying to decide if he wanted to go with a cash buyer or if he wanted to list as is. Now, in his case, when we looked at the cash offers, I steered him towards the legitimate buyers. There are some in my market who I say are not legitimate because they have no intention of buying the house. They just want to get it under contract. I know who they are. I meet with them once a month. They're a good agent knows who the buyers are in the market that can follow through and who can't. So that's where someone in your market who understands probate and probate process and who the cash buyers are that operate in that space can really save you a lot of time, a lot of money, and a lot of headaches, because when things go wrong, you have to go back and start over again. Ask me how I know that. I was a personal representative twice and a special administrator once. The first time through, I accepted some offers from cash buyers that were not legitimate. I had to go back and start the process over. Don't make the same mistake I did. Save yourself time and money. I didn't make that mistake the second time, didn't make that mistake the third time. And my families I work with don't make that mistake at all. But anyways, the last option is to list with repairs. This is where you're going to make repairs and you're going to get 100% of the true market value or the after repair value of the home. But in order to get that, you have to make repairs. And this is what most of your traditional agents who don't understand probate are going to recommend, because this is what they've been trained to do. And it's true. In most cases, you are going to gross more money if you make repairs and list the house. However, this is probate. This isn't a typical situation. And in probate, time is money. And if you want to spend another 3 to 6 to 8 months repairing the house to get it ready, you still have holding costs, probate costs, attorney fees, and all these other things that are adding up faster than you can imagine. In addition to that, when you start making the repairs to the house, it completely changes your knowledge of material facts and how you would disclose, which also has a ripple effect and changes how your real estate agent and your attorney are able to use the waiver of liability, which is really important to you and the estate. And so that's not something that is typical in a typical situation, but is really critical in a legal process like probate. And so you want to make sure that if you decide to go down that path, you really know what it takes. Now, I recently was contacted by a family and their attorney transferred the title before they completed probate. So they were going through probate. The attorney transferred the title into the names of all of the beneficiaries, so they were joint owners of the property. And then they were going to fix up the house and sell it outside of the probate process. They just wanted to close probate as quickly as they could. Well, then after it was time for them to sell the house, they realized what the repair costs were going to be, how long it was going to take, how much it was going to cost to keep the house, and the tax implications from selling the house after probate versus selling the house during probate. They didn't work on any of those things with their attorney, and they were very unhappy. At that point, they really didn't have many options I could think of. I Other than sell the house, I advised them to talk to a tax accountant, but you can't go back and do it over. So when you are making these decisions, it's important to work with somebody that can help really guide you through these decisions and understand what the impact is going to be on you as personal representative, on the family, on the estate, and then also after probate, there could be impact if you don't do it properly. Now that we've determined our approach for selling, now is when I recommend you clean out the home. And the reason is because depending on which approach you're going to take determines how much time you're going to put into cleaning out the home. Remember, I said we want to get through probate with less stress. Well, if you determine your approach for selling and then you clean accordingly, you can save yourself a lot of stress. So, for example, if you decided you're going to sell to a cash buyer, then really all you need to do is make sure you remove the items from the property that you want to keep or keep in the family, and you can leave everything else for the cash buyer. If you want to have an estate sale or sell some of the personal items, then you can sell the house to the cash buyer as soon as you complete the estate sale or the online auction, right? If you're going to go with an iBuyer, you need to get everything out of the house. So we need to do more work to get the house cleaned out. Same thing if we list as is, although sometimes what I will do when the family's listing as is, we will let the buyers determine what they want to keep, and then we will get rid of the remaining items. And so that makes it a lot easier to get the house cleaned out, and the buyers feel really good because they're getting a bonus, or they feel like they're getting a bonus. If you're going to list with repairs, you're going to have to get that house cleaned out and rehabbed and in top condition. So if you determine the approach first, and I know a lot of families, they'll go through the process of cleaning out the entire house, and then they'll decide to sell to a cash buyer, and they could have just saved themselves a lot of time and money by deciding to sell to the cash buyer and then doing very minimal clean out. So this is really important. And again, if you're working with an agent that has all of these options, then it's really important to come up with a plan so you put the least amount of work and have the least amount of stress possible. And for cleaning out the home, I'm going to create another video for you on that, but there is a process for that too. Number one, get everything you want to keep out of the house. Number two, decide if you're going to sell any of the items, whether that be an online auction or an estate sale. Some families like to do it themselves. As far as the healing process, that's great, but it's really stressful. It's just adding to your stress. So decide what you want to do there. After you have sold the items you want to sell, then you take and donate as much as you can. This is important because it's going to help you on your personal taxes and taxes for the estate. And your accountant can talk to you more about that, but just know that by donating, there are going to be some benefits for you. Then after you've had your sale, after you've done your donations, then that's when, if you are needing to get the house cleaned out completely for the iBuyer or the as is, that's when you have the clean out crew come in and remove the remaining items. And by doing the sales first, you are bringing money in. Then by donations, you're getting some tax benefits. And then by doing the clean out crew last, you're saving a lot of money because at that point, there really shouldn't be that much left in the house anyway. So talk to someone who can guide you through the process, determine the approach best for you, and then clean out the home accordingly. It'll save you so much time and so much stress. One more thing here is this is where we're also starting to bring in offers, right? So we're bringing in offers from those cash buyers. This is, again, I mentioned in phase one, you want to let your family know that you're going to sell, and if they want to buy the house or keep it in the family, they have to get pre-approved. Now that we have offers coming in, and we're getting multiple offers for the court and for the family, I'll talk more about that in a minute, but as those offers are coming in, This is where if someone in the family wants to keep the house or keep it in the family, I give them the opportunity to match the best offer that we have. And this is really important because as the person selling, your fiduciary responsibility is to get the most money you can for the estate. If someone in the family is willing to match the best offer that you have coming in and you want to keep the house in the family, you can accomplish both. They can buy it based on the price in the best offer, and you still get the amount of money that you wanted to get for selling the house. Works out great. And then if they deduct their portion of the inheritance from the sale of the home or the money that they're buying it for, they're buying it for even less. And so they're happy, you're happy, as happy as you can be during probate. But everybody's satisfied that they got their way. A lot of times I'll see families lock horns where one person says, no, we're selling it no matter what. Someone else says, no, we want to keep it in the family. You can do both. There's a way to do it. And I just mentioned it, and we could talk more about that in another video. So that is the appointment phase. What other tips do you have? What concerns do you have? Let me know in the comments below, and we will jump into the administration phase. In the administration phase, this is, again, I mentioned in the appointment phase, you get your letters. So in the administration phase, now you can go to the bank, right? Remember, you wanted to go to the bank during the pre-probate phase. I said, no, wait till you get your letters. Now you have the letters. Now you're going to the bank in the administration phase, and you're opening up an estate account, and you're taking care of any other accounts. So maybe transferring money or closing accounts, closing the decedent's account. When you do that, if you don't have online banking, if you're closing their account and you don't have online banking, ask if you can get the records from the last 6 months or the last year. I like to do that for the court. When I'm personal representative, I like to get the records for the last year and just keep those in a PDF so that if the judge or someone in the family wants to see where the money went even before I had an estate account, I can go back and show them where the money came from that we put into the estate account and what money was going out of the decedent's personal account prior to that. When you open up the estate account, try to get the online banking. This will help you with your final inventory or your inventory and accounting, which will come at the closing phase. So if you can get the online banking, then there's a record of all the transactions you're doing. If you combine that with the records from the decedent's account before you closed it, you're going to have almost everything you need for the not the inventory accounting, but the final accounting at the end. Number 16, get estimates and appraisals. I could do a whole video just on this. As I mentioned earlier, I bring all of my families at least 3 offers. And a lot of times the judge will say that that will suffice in lieu of appraisals. And then if we're giving family the opportunity to purchase the home based on the highest offer, then a lot of times that'll keep the rest of the family happy as well. I will do the appraisal or have the family do the appraisal if the attorney and the judge insist. In some states, they do insist on an appraisal, or if it's a formal probate, they might insist on the appraisal. But you would be amazed how many cases and how many times it's really not necessary. People think it's completely necessary all the time. It's really not. We can get by with estimates and multiple offers in lieu of appraisals in many cases. If there is personal property, something like a gun collection or some kind of collectible china set, whatever someone in the family thinks is valuable, a lot of times I will get appraisals on that. And that way it helps justify to the court what we decided to do with it. But I don't get appraisals on everything. You don't have to get someone to come through the house. You could just ballpark, personal property, 5,000 or 10,000. The car, you can look it up online. The stocks and bonds, maybe they're not part of the estate because they had a beneficiary. The house is pretty easy, right? It's not as hard as people think, as long as you don't try to get specific appraisals for every single piece of personal property. Number one, it's not necessary. Number two, you will drive yourself crazy. Ask me how I know. Sorry. Number 17, you are going to sell the assets and pay off the debts. So this is the administration phase. This is where you are now liquidating assets and you're paying off the debts. And when you pay off the debts, you close the accounts. And as you go through it, if you're doing what I recommend, you're communicating with the rest of the family so they know what's going on, and you constantly have to resolve inheritance issues. This is important because at this point, people in the family have been waiting a long time. They want to know why they didn't get their check, why nothing's happening, right? You're working through this process in an orderly manner. They're just sitting there wondering why it's taking so long and why they didn't get their check and what the hell are you doing? Ask me how I know that. All right, number 19, I mentioned your closing accounts as you're paying off debts. Again, if you haven't talked to the bank at this point, this is when you should be talking to the bank. Also, if the house is going into foreclosure because someone missed mortgage payments, you have your letters of administration. You should be working with the bank or the mortgage company at this point. And those are the administrative tasks. We could get a lot more detailed. I want to keep it high level for you. What's happening with the house at this point during the administration phase? This is when you're actually selling the house, right? So in the appointment phase, you decided your approach, you started getting some offers. Maybe you put the house on the market. You let family know that they can purchase the home if they want to. They were getting pre-approved and pre-qualified. Now it's the administration phase. It is time to sell the house. In many cases, you can, if you've been authorized by the court with your letters, you can sell the house. In some states, you still need to go back to the judge and get them to approve the sale. The myth here is that that's not true in every case. It is true in some. So you just need to make sure you know, and I mean really know, don't just assume it. Like make sure you know whether you need the judge to approve the sale of the house or if your letters of administration are all you need. Because again, you could wait months to get a hearing only to find out that you didn't need the judge to sign off. You could do it yourself. So, and I see families make this mistake all the time and it costs them a lot of money. Or if they are working with an agent who doesn't understand the probate process, they're talking to the attorney to see if they can do it and they're waiting for the court and a court date. And in the meantime, the house is sitting there and you're paying the insurance and the utilities and racking up all kinds of expenses when the experienced agent could have just told you that you're authorized to sell the house. Save you a ton of money. Stop the utilities at this point. This is where it becomes more like the normal traditional process. You're at title closing and you're stopping the utilities. And a hot tip here, number 22, if you're keeping the house in the family and the person who's taking it over, so let's say you live in the house and you're going to keep the house, you're not, and maybe you're the only heir, maybe there are no other heirs. So you live in the house, you're keeping the house, there is no mortgage, you're the only heir, and you just figured, okay, this is great, we're good to go. Even in a scenario like that, make sure you transfer the title. Even if the house is not, get the title transferred into your name before you complete the probate process. It'll save you so many headaches down the road. I can't tell you how many times I talked to people who decided to keep the house or keep the house in the family, but they didn't transfer the title. And they lived in it for years. They paid the taxes. Some cases they paid the mortgage payment. They fixed the roof. They put in a new furnace. They did all these things. And then they want to sell the house and they find out that they have to go through some form of probate or shortened up version of probate, decree of descent or summary judgment or something else through the courts in order to transfer the title. And then when they go through that process, they have to notify other potential heirs and family members. And these people start popping up saying, hey, I want my cut of that house. When you took it over, it was worth 200,000 and today it's worth 600,000. I want my share. So just avoid that, right? Our goal is less stress. Transfer the title now. You will have much less stress further on down the road. All right. Closing of the estate. Oh, before we do closing of the estate, what other tips do you have for administration phase? What other questions, comments, or concerns? Please leave them in the comments below. Now let's talk about the closing phase. In the closing phase, you want to, as personal representative, you want to prepare the final accounting. A lot of people freak out when they get to this point. If you have done your online banking and if you have been keeping track of your expenses, again, I would do all of mine through the debit card and through the bank account so that I had the ledger. All I had to do was download and it was ready to go. And then you just take that, you put it into buckets based on the form that your state wants you to use. There's going to be a big bucket for big assets like the house, probably another one for the cars. Uh, I call out anything that's collectible. And then I just have another bucket for personal property. If we did an estate sale, we know the value of that personal property because we got paid. If we did the online auction, same thing. When we donate, we were getting receipts. We checked with our accountant, so we have an idea of what the donated value of those items are. You just put them onto that final accounting sheet, and then if you are not working with an attorney, you send it directly to the court. If you are working with an attorney, your attorney will give you some tips and make it better. My attorney, I'm pretty good with my final accounting sheet, but my attorney always makes it better every single. I don't know if it's just because that's part of the billing process, but they always make it better. Um, Now is when you distribute the net proceeds. So you've completed your final accounting, you're getting ready to close out the case. You now distribute the remaining money to the rest of the heirs. This is the day that a lot of those heirs have been waiting for, sometimes for months, sometimes for years. And when they get their money, they're not always going to be happy. And here's why. If you have not been communicating with them throughout the process, they do not realize all of the work that you've been doing, all of the expenses that you've incurred, how much it costs to close an account. All they know is that Zillow says you sold the house for $500,000. And they know that there's only two heirs, and so they should be getting $250,000. They're not taking into account the mortgage. They're not taking into account the monthly expenses. They're not taking into account the extra time that it took for them to have a yard sale rather than doing an estate sale. They're not accounting for the extra utilities you had to pay to keep the house on the market when you wanted to sell it as is. So they don't know all these things, and they might be a little frustrated, a little disappointed if this is the first time they're hearing about it. So again, if you've been keeping them informed throughout the process, maybe they won't be shocked here. But a lot of times they're and also I think there's an emotional side of it. They're it's kind of closure. They're disappointed. You're relieved that this thing is over, but some people are disappointed that this is over. It might have been dragging out for years and years. And so it's hard even when you distribute the net proceeds, and it's harder if you have not been keeping the family informed throughout the process. Then you work with the court or the attorney to close the estate. It's basically just submitting a form and the judge approving it. And at that point, you're done with probate, and it's time to try to repair your family relationships because those get strained throughout this process, even when you're doing a good job. And then last on the real estate side, I already mentioned this, but if you are keeping the house in the family or if you sold the house, make sure the title transferred so there are no surprises later on. Try to resolve those title transfer issues while you are the administrator, while the estate is open. And then when you close the estate, title should be transferred, you should be good to go. I know this is a very long and drawn out process. I did not include all of the steps. I tried to keep it high level. If you follow these steps and do these things in order or in close to order, you will avoid a lot of problems and a lot of stress. A lot of times in probate, in addition to family, the stress will come when you start doing things out of order. Okay, so I already mentioned this, but if you try to sell the house while you're in the pre-probate phase, it's going to cause a ton of extra stress and you won't be able to do it. You'll have to go back and start over. If you try to negotiate with the banks before you have your letters of administration, it's going to cause a ton of stress and frustration. If you are waiting to, if you're waiting to get the house cleaned out and repaired until you get some kind of approval from the court. Again, lots of stress. You don't need court approval to do that, but you do need to keep a good record because someone's going to ask you about it at some point in time, right? So a lot of these things, if you just do them in order, probate is frustrating enough, but this will help relieve some of the extra stress and frustration that comes when you take these things out of order. And again, if you have the benefit of working with an agent who understands probate and the probate process, that'll help. Even if you decide not to list the house with a probate specialist, I highly encourage you to talk to one anyway, just to come up with an approach and a plan. And if I could do anything to help you find an agent to work with in your state and in your county, just drop me a link or an email or a text and let me know. And we'll do everything we can to help you get on the right path, even if you never sell a house with us. We're here to help you. So thanks and have a great day.